you all for coming and for your interest in this important set of issues, which obviously, given what's happening in the news right now, is more critical for us than ever as people who care about the Constitution. My name is Mitra Ebadolahi. I am a staff attorney with the American Civil Liberties Union in San Diego. I was previously a staff attorney with the American Civil Liberties Union in New York with the National Security Project, where I was part of the team that litigated Amnesty versus Clapper, the case challenging the FISA Amendments Act, which the Supreme Court threw out in February. I'll talk about that a little bit more in a moment. We are going to talk a little bit, each of us, about our various takes on surveillance and the NSA and whistleblowers, and then hopefully open it up for discussion and questions from you about this set of issues. And my purpose is to give you some background on how we came to live in the surveillance state that we are now in. And my sort of overarching message is that we are witnessing an abject failure to protect the Constitution on behalf of all three branches of government, the executive, our legislature, and our judiciary. And so the key question in my mind that I want you to think about as we talk is, how do we come to get to this point, and what do we do to undo some of this damage? Just to start at the beginning, or where I think the beginning is, in 1975, the Senate formed a bipartisan committee known as the Church Committee, and it was designed to investigate allegations of surveillance abuses committed by the executive. The Church Committee reviewed the activities of various United States agencies, including the FBI, the CIA, the National Security Agency, the NSA, the Department of Defense, and the National Security Council. And it looked at the activities of those agencies for a period of time ranging from the mid-1930s through the mid-1970s. The committee found that intelligence excesses at home and abroad have been found in every administration, and concluded that many presidential administrations had collaborated with intelligence agencies to break the law and overextend intelligence operations. Specifically, the Church Committee found a pattern of intelligence investigations with vague or imprecisely defined mandates, which in turn provided intelligence officials enormous discretion with which to choose their intelligence targets. Often, the targets of government surveillance were chosen based solely on domestic political considerations. The most perhaps famous example was the FBI's targeting of Dr. Martin Luther King Jr. in an effort to, quote, neutralize him as a civil rights leader. The FBI used nearly every intelligence technique at its disposal, including electronic surveillance, to obtain information about Dr. King's private activities and to discredit him and his advisors. Also, between 1960 and 1972, the FBI subjected nearly 30 American citizens to electronic surveillance to determine sources of leaks of classified information. They found no such leaks. Instead, they conducted the surveillance without judicial approval and based on little or no individualized grounds of suspicion. At least 7 of their targets were journalists. And ultimately, what the FBI ended up with was a lot of personal information and political information about people who they had decided to target. In the end, the Church Committee issued a series of recommendations that were designed to better safeguard Americans' privacy, expressive, and associational rights. One key set of recommendations involved judicial oversight of intelligence operations. Specifically, the Church Committee identified 3 characteristics of U.S. intelligence that, unchecked, had led to violations of the rights of American citizens. And if I tell you what those 3 are, it'll sound like I'm talking about today. 1, excessive concentration of power in the executive branch. 2, excessive secrecy that shielded, quote, constitutional, legal, and moral problems from the scrutiny of all 3 branches of government and from the American people themselves. And 3rd, a general sense of lawlessness that pervaded the intelligence field, causing government officials to use national security rationalizations as a pretext on as a pretext to evade statutory and constitutional limits on non-security related surveillance. After the Church Committee issued its report in 1978, the Foreign Intelligence Surveillance Act, FISA, was passed into law. FISA set forth a comprehensive procedure through which, with limited exceptions, officials had to obtain a court order before engaging in any surveillance of communications to or from Americans located in the United States. The FISA scheme created a special court that was supposed to serve as a check on executive surveillance activities, the FISC. The government had to apply to the FISC for permission to conduct foreign intelligence surveillance in the United States, including surveillance of communications with American citizens into and out of the United States. The FISC application required identification of a specific target, the specific facilities or places used or about to be used by the foreign power or agent to which surveillance would be directed, a detailed statement of the facts or circumstances that gave rise to the government's desire to surveil that target, and minimization procedures designed to limit the extent to which that surveillance implicated the communications of the American people. In reviewing the application, the FISC judge was actually required to find, on an independent determination, probable cause to believe that both the target of the electronic surveillance was a foreign power or agent, and that foreign power or agent was using or was about to use each of the facilities that the surveillance was going to be directed at. After 9/11, George W. Bush secretly authorized the NSA to conduct surveillance of communications between Americans and foreign parties without FISC authorization, claiming his wartime powers. This surveillance, which was known as the Terrorist Surveillance Program, was just one part of the still secret President's Surveillance Program, a much larger program about which we still don't know everything. The TSP, the Terrorist Surveillance Program, was revealed through a series of groundbreaking news reports in 2005, resulting in public outcry. That led the Bush administration to pressure Congress to amend the FISA. The ultimate result was the FISA Amendments Act of 2008. The FISA Amendments Act allows the executive branch to circumvent many of those key judicial safeguards that came out of the Church Committee recommendations and led to the original form of the bill in 1978. Unlike the FISA Amendments Act does not require the FISC to issue an individualized order after meaningful judicial review, and does not permit the FISC to engage in continued oversight of ongoing surveillance. The statute eliminated the probable cause and individualized suspicion requirements, and the government can now obtain orders authorizing surveillance for up to 1 year simply by certifying to the court without any independent review that its targets are reasonably believed to be located outside the United States. What that means is that our communications can be swept up as long as you're talking to someone who's outside of the United States. The FISA Amendments Act thus has dire and immediate consequences for those Americans engaged in routine international communications with clients, sources, witnesses, experts, dissidents, and advocates abroad. It opens up our international emails and telephone calls to warrantless surveillance, impeding the confidential communications integral to such professional and personal activities. Immediately after the FISA Amendments Act became law, the American Civil Liberties Union filed a lawsuit challenging the statute's constitutionality. Our plaintiffs included attorneys and human rights, labor, legal, and media organizations whose work required sensitive and at times privileged international communications. The government, including the Obama administration, argued that the plaintiffs lacked standing to sue because we couldn't prove to a certainty that we were being secretly surveilled. Notwithstanding the uncontested fact that the government was engaged in the very types of surveillance that the FISA Amendments Act was designed to allow the government to collect. The Supreme Court heard argument last October, and this February held that we could not satisfy Article 3 standing requirements, throwing our lawsuit out. Justice Alito's majority opinion identified a, quote, highly attenuated chain of possibilities insufficient to establish that our alleged injuries were certainly impending or fairly traceable to the FISA Amendments Act, and emphasized that we cannot know whether we have been subject to secret government surveillance pursuant to the FISA Amendments Act or instead other authorizations. A powerful dissent from Justice Breyer explained that the majority forgot to assume that the government is just doing its job to conclude that there's a high probability that we are in fact being surveilled. Unfortunately, Congress reauthorized the FISA Amendments Act for 5 additional years last December with not a single amendment designed to protect our constitutional rights or increase our privacy. So that's how we came to where we are. The FISA Amendments Act is one of the many pieces in this very troubling mosaic eroding our core constitutional values and our privacy rights. And Lee now is going to talk about additional efforts to, through litigation, hold our government officials more accountable.
Hi, so I'm Lee Tien. I'm a senior staff attorney with the Electronic Frontier Foundation. I've been working on these kinds of national security surveillance issues pretty much since 9/11. We tried to stop the Patriot Act from being passed. That failed. We tried to sue against the warrantless wire. I mean, much like the ACLU, our efforts have been both combined and parallel. Unfortunately, we've run into a lot of problems along the way, and Mitra's summary, which was amazingly comprehensive, but had to miss a lot of the details because there was so much to cover. I want to single out a couple of big themes and then talk about what both our organizations are doing now to try to do something about this problem. The first big theme I want to hit is simply secrecy. The secrecy that surrounds the national security apparatus, national security surveillance, has become even more impenetrable over the years. Many of the lawsuits that have been brought to try to challenge this kind of unconstitutional, illegal activity have failed because of secrecy in two different ways. The first way is that because it's secret surveillance, you don't know if you've been surveilled. And if you don't know you've been surveilled, then you run into the standing problem that Mitra was talking about. You walk in there and you say, this is unconstitutional, and they say, did it happen to you? And you go, well, we can't really be sure because it's a secret. They say, well, gotcha. So that's our big catch. That's one of the big catch-22s. It's, you know, any of you are lawyers. We were all bored by standing in law school, but it is a killer. The second, state secrets privilege. We ran into this even with plaintiffs that we thought had standing. And what happens is the government tries to put a cloak of silence over everything, even if it's available from other people. Simply put, they want to say that this information is so secret that you cannot litigate about it. It is harmful to national security for us to even talk about its existence. That's simply not the way to have any kind of accountability in a democratic society. It's shameful when it was done by George W. Bush and Cheney, and it's even worse, in my view, when it's being done by a president we worked very hard to elect. So what are we trying to do right now? Well, as you all know, the Snowden leaks have led to a lot of really, really interesting revelations about what the government's doing. Most of them are really more confirming what we were concerned about before, or adding details like, I didn't realize how many of our favorite Silicon Valley companies appear to be in cahoots. You know, we were always blaming AT&T because everyone hates AT&T, but you know, Apple, I mean, really? But nevertheless, that's where we are now. The PRISM program, which is the part of tied into all of this 702 collection, which is ostensibly for non-US persons outside the United States. Somehow, when we looked at the minimization and targeting procedures that came out of the Snowden revelation, we realized that, you know, the idea of inadvertent collection of Americans' information, I don't think that word means what you think it means, right? I mean, all of their documents are about how they're going to hang on to and process all of this incidental communications record. It's the sort of stuff that they've been lying to us about, and yet they have the temerity to then say, well, but you could see it from the statute, even though at the time they were denying that it was actually going to be used that way. We have a lawsuit right now, as ACLU in the Southern District of New York. We are each separately challenging the other main shoe that dropped. And this was actually maybe the first or the second shoe, which is the so-called telephony metadata collection program. This was the order coming out of our friends at the Foreign Intelligence Surveillance Court under the authority of Patriot Act, Section 215. basically ordering Verizon to cough up, well, I'll be precise, Verizon Business Network Services to cough up all the information about its subscribers. That included cell phone identities such as IMEI, IMSI, as well as the length of the calls, what were the numbers called to, dial from, et cetera, et cetera. A huge amount of really, really useful communications data or metadata. That's, I think right now is this is one of the big issues for the courts, is they're going to have to change their position. The government's been saying for years, well, there's no Fourth Amendment reasonable expectation of privacy in the metadata. Sure, your communication themselves, what you say to each other, but the numbers, no, that's not right. In fact, I've had dinner with judges where I'm arguing with them about this. The phone number, that's just, that's in the phone directory. You can't possibly tell me that anything made up of something that's sort of like in the phone directory could possibly be private. This is I think, I'm not going to insult you. You all know that 5 years of 10 years of records of every phone call you've ever made, or every call that's ever been made to you, tells an enormous amount about who you are and what you do. There's just no denying it. Right now the courts haven't gotten there. Part of our job is to get the courts to finally say so, and then rein in the rest of the government. Now, our particular lawsuit on the 215 bulk collection order is entitled "The First Unitarian Church of Los Angeles versus the NSA." We've got a bunch of different defendants. We've got the churches. We've got the Bill of Rights Defense Committee. We've got the Cal Guns Foundation. We've got Greenpeace, Human Rights Watch, People for the American Way. We're trying to, we have got a broad ideological range of plaintiffs. All of them have one thing in common. They are activists. They are working to try to accomplish political change or community change, and they do that by working together, communicating together, and we all realize that that's not just about sort of the naked, simple Fourth Amendment privacy. This is about the First Amendment, the right to associate and the right to have privacy in our associations, the kind of right that we really sort of seminally saw in NAACP versus Alabama, when the state of Alabama tried to get the membership records of the NAACP, and they stood up and the Supreme Court actually said, yeah, that's not something that the government should be able to force them to get. We think the logic is really, really quite clear. In the very same way, none of these groups or any other group that's legitimately assembling and working together on political, religious, or other social and cultural causes should have the government be able to willy-nilly just collect all of their communication records. That's just got to be wrong. And so our first core claim is First Amendment, chilling effects on association. And the First Unitarian Church of LA is really, I think, they have a pretty storied history. We were really glad to get them. They resisted the McCarthy hysteria and defended a lot of Hollywood writers. In the 80s, they gave sanctuary to refugees from civil war in Central America. And it is part of their stance that their church has to take positions on controversial issues. And so that's why they're part of our lawsuit, because they know it's actually part of their mission as a religious group to engage in this kind of change. We also have, I think, in our case, the kinds of claims that you would expect. We make the standard and somehow losing, but it should not lose, claims about the Fourth Amendment, right? I mean, if leaving aside the technicalities of metadata, one of the reasons why the framers put the Fourth Amendment in the Bill of Rights was to grant what they called general searches or general warrants, the ability of British colonial customs officers to sort of get blank checks,
search free cards. As far as we're concerned, anything that looks like that 215 order might as well be a, yeah, just go ahead and search for a free card. We also argue that the Fifth Amendment vagueness doctrine ought to be in play here. That when a law like Section 215 is written to say that the records have to be relevant to an investigation, and yet somehow they manage to squeeze all of those phone records from people that they know and that they've actually admitted don't have any connection to terrorism, and somehow that whole pile is relevant. That means that's not a law that you and I, as Americans, or even the legislators who passed it, they don't know what it means. Nobody knows what it means. And the reason why we don't know what it means goes all the way back to secrecy again, right? Because we've got secret courts rendering secret interpretations, and then the executive branch happily moving with that. I'm going to end on a point about the legislature. I think one of the things that's happened over the last few years, it's been very easy, especially when President Bush and Vice President Cheney and Attorney General Ashcroft were in power, that it was really, really easy to, people you love to hate, right? Congress now, though, is in a position where they have voted for some of these hateful, awful things over the years, and they feel like, a little bit like they're trapped. They're going to be pilloried for having voted for it before. They would like to lay low. They would like to hope that the public's anger subsides and that it will be someone else's problem. Right now they're hoping it will be the president's problem. He's only going to be around for a couple more years. The thing that I want to make sure of, though, is that there's at least 438 folks in the House of Representatives who have to think about their election in 2014. That's a very real thing for them, the way that it is not real for the NSA spies, or the guys in the FBI, or even the man in the White House. There's also 33 1/3, I guess, senators who will have to think about their political careers next year. If you don't take anything else away from what I've said today, and I hope that you really think about how we can get our elected officials to take seriously this secrecy problem, this surveillance problem, and actually for Congress to just sit there and actually man up and look at what is happening. We've got intelligence committees with access to it, but with Dianne Feinstein as the head of Senate Intelligence, we're not really any better off than if some Republican were in charge of it. How are we going to make change happen? How are we going to reform the FISA court? How are we going to get rid of an outmoded classification system? These are the things we're all going to have to face, and I think we're going to have to take it to Congress.
I'm Scheer, and I didn't realize I had such a fan base in Orange County. Actually, I lived here for 10 years, and my wife was the editor of the LA Times in Orange County. I was sentenced here for 10 years. So I got stuck somewhere around, coming in past Costa Mesa. I thought I'd never do this again. And the reason I wanted to be here is I do think that we have to rally interest in the Democratic Party. And so I had the chance to come here. I thought, well, let's do it. And the fact of the matter is that Democrats haven't really been any better than Republicans, obviously. The proof of that is that the two people who were very quick to condemn Snowden as a traitor were Dick Cheney and Dianne Feinstein. Used the same word without any trial, without any investigation, hours into revelation. By the way, information that yet we have not seen one scintilla of evidence that has harmed anyone or harmed national security, and everyone agrees it's provoked a national debate that is long overdue about privacy and secrecy, and without those revelations we would not be having the debate. And even in this group, they said earlier, there was no vote for a privacy seminar. We are here thanks to the leakers, Assange and Manning and Snowden. I remember a point, it was just before 9/11, I did a cover story for Yahoo Internet Life. They had a magazine, and it was about privacy. And I did it because I was very involved with the internet and using devices. We set up, I used the first Stanford Moscow teleport. I reported, I went from Microsoft on a trip in Southeast Asia. I actually covered the coup in Cambodia. So I was aware of this new technology. And it hit me, as I wrote in that piece, that this new technology was sort of a dictator's wet dream, a Stalin or a Hitler. And I operated in totalitarian countries at different times. And what would you have? You had crude, you knew you were being followed, there would be some wiretapping, some attempt to get your papers. But in the main, it was very limited by today's standards. And what you have now is something that no dictator ever could imagine. We voluntarily give over enormous amount of information. Just to get to that Hilton Hotel, I had to tell 3 different services, yes, you can use my location. You can find out where I am. Let me surrender. Yes, I accept. And we all do it all the time. I edit an internet site, and I can tell you, without betraying, without placing cookies, I can learn a great deal about your reading habits, how long you stay on each column, where you email it, how you respond, and so forth and so on. So we live at a time where 3 things really have changed. One is we have this incredible pool of data. You don't have to be stationed outside someone's home. You don't have to be doing that kind of stuff. We voluntarily give it up. What books we read, what we download, and so forth, all of our habits. Secondly, we have these supercomputers that can do searches in this data. And they're very happy in the case of Boston. They can compare 20 million facial things, find out little differences in your eye and so forth. Boom, 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 boom. And in addition to having this revolution in information and being able to target people and know where they've been and who they've associated with and so forth, whether they're involved in an Arab Spring or there are people here in Orange County, we have the excuse, and that's something I want to address. And the excuse is we have terrorism. Terrorism. And terrorism trumps any other danger we've ever experienced. Right? That's the bit. I know you don't believe that, but that's the argument of a Dianne Feinstein. You know, they're saving the country. NSA is needed. We face an enemy we've never faced before. And that trumps any concern about civil liberties, our individual freedom, our privacy. Now, it's a bogus argument. And I just want to address that very quickly. First of all, I want to read the 4th Amendment. We tend to take it for granted. It's sweeping. And it was, as pointed out, it was a response to what the King did, it was back to common law, and it's basically a very important notion, I mean, more basic than the First Amendment. It says if you don't have private space to stand on, to collect your thoughts, to mull over ideas, to send those letters that Washington and Jefferson and everybody sent, to keep a diary, to make mistakes, to cross out things, without being observed by the state, whether it's the King, you don't have the basic ingredient for freedom, because you don't have the place, the incubator for free thought. It's absolutely critical, okay? And they enshrine this in the 4th Amendment, so let me just read it to you. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Very specific. What was discussed here before is the vacuum cleaner. every bit of data scooped up all over the world, unsuspecting, no guarantee of opting in or anything else, all available to be sifted through. It's the most fundamental violation of this guarantee. Now, where do we get the guarantee from? Oh, they say, well, those founders of our country, they didn't know about terrorism. Okay? That's the argument, okay? No one's lived in a time. It's a bogus argument because no people have ever been more secure than we in the United States at this time. No people have ever been more secure from foreign attacks, okay? From being put under the yoke of dictator unless it's one we vote for. And if you think the condition of the founders, it's really amazing. These people were in a situation where, first of all, when they're making their revolution, maybe they only had 1/3 support, a real strong support, and another third might have been with the king, and another third might have been indifferent. And they knew it could go against them. And if it went against them, they knew every member of their family would be hung from some tree, and all of their property seized and everything else. So these founders of ours faced as great a personal risk as any people who ever wrote any shrine of any freedom. We should not take that away from them. And in putting these strong words down, they know it can come back to haunt them. They knew they were constructing a government in which they would be judged, and yet they put these absolutes in there. Free speech, free press. The other thing I would point out to the founders is they were very concerned about this appeal to patriotism. In George Washington's farewell address, which we had 8 years to develop, it was going to be one term, he was preparing it, he consulted with Madison and Jefferson and others. There are some strong words there about patriotism. And he said, beware of the impostures of pretended patriotism. And he warned against the foreign entanglements. And he made the basic argument, you cannot be a republic and an empire in the same moment. If you want to be a republic, you better tend to your own businesses. You better have governance over an area you can understand and control. When you move to empire, you go down Rome, France, Spain, England, all the examples they have. The two are in conflict. That's one reason, by the way, we have support for privacy and against the surveillance state on both sides of the aisle, and we have opposition and indifference. And that, I will say, and I'll probably get booed for saying it, but I respect the fact that Rand Paul has helped lead the fight on surveillance. I respect the fact that there is a libertarian support for this position. And it's a recognition this is not a left-right issue. It's a basic notion that you believe in governance of free people and their control over the society. Now I want to address, finally, because we want to have time for questions, I want to address this question of security, national security classifications over the post-9/11 hysteria. And I want to say, not being a lawyer, but being a journalist, I've had lifelong experience. Some of the stuff we did at Ramparts magazine was the reason why you had the church investigation and stuff on the CIA. And any journalist who's honest, and that does not, unfortunately, not include all the talking heads on television, will tell you that well over 90% of what is called news coverage is dependent upon leaks when it comes to international relations, banking, main facts of commerce, and so forth. And almost all of that reporting comes out on a selective process where people pushing one side of the debate, usually in government, usually in a position of power, leak information that has the stamp of classification, secret, privacy. And they are not punished. And I want to give just a few examples. If we look at, well, I'll give only 2 examples on that side. I took a plane from, actually I was living here in Orange County, and I took a plane from John Wayne Airport up to San Jose, and I was on my way to Stanford, where I was a member of an arms control panel that had Condoleezza Rice, which was the other person, Cedrell and others, a number of people who were in the JASONs, they had high security clearance. And I was on the plane, I was a reporter for the LA Times, certainly a suspect character, certainly known to be critical of weapons systems. And on that, after I got off the plane, I was getting off the plane, I ran into Edward Teller. Most of you seem to be old enough to remember Edward Teller. And Edward Teller said to me, where are you going? I said, we chatted, I knew him, I was friendly with him, I'd written about Livermore. And I said, oh, I'm going up to the arms control thing at Galvez House at Stanford. He said, oh, he said, make sure Sid tells you about the great results we got on the cottage test. Now, the cottage test was part of a number of tests named after cheeses that we weren't supposed to know that had to do with nuclear tests. And the cottage test was testing for the effect of lasing from a nuclear explosion. And it was behind the whole Reagan Star Wars notion that you could make a weapon that could zap everything. Okay? So Teller was basically referring to what was really the most important secret of our whole defense system. Okay? And he said, we got great results. Now, I'm not supposed to know the cottage test is a nuclear test. I'm not supposed to know it's about lasing. And I'm certainly not supposed to know they got great results. And if there was one piece of information the Soviets would have liked to have, it would be that. Okay? There was anything else you could possibly know. And Edward Teller was doing what Edward Teller always did. He was plugged into the government. He was plugged into the military-industrial complex. And he was making the case that he convinced Reagan on to go for Star Wars, you know, and not worry about screwing up any arms control agreements and so forth. So I got up to Galvez House and I see Sid Drell there, and he's got the highest clearance, being adjacent. And I said, hey Sid, I just ran into Edward Teller down there at the airport, and he said they got great results on the cottage test. And Sid Drell turned white. This is out. And we go outside for a walk, and he says, what the fuck are you talking about? You know, and I said, reasonable guy, I think he was from Brooklyn originally, and I tell him, Dad, he said, you go to jail forever, what are you doing? I can't talk about that. I mean, he was livid about it. Well, to my mind, it was typical of the way the information was leaked. If they had a weapon system they were pushing, they would give you details of those systems. On the other hand, if they were making a different argument, we talked about your uncle, who was the chancellor here at UC, Dr. Tien, and then became the chancellor of Berkeley, and I remember he was on the committee of 100, which were leading Chinese figures, came to the defense of a guy named Wen Ho Lee. I don't know if you remember the Wen Ho Lee case. Okay? Wen Ho Lee was a guy who was framed. All right? And they said he was a scientist in Los Alamos. They said, no, he's giving the greatest secrets in the world about the WA-40 warhead and miniaturization. These are really top secrets. And it turned out to be bogus. He was cut loose after 9 months in solitary. Those stories in the newspaper, the New York Times, were based on leaks from a congressman here in Orange County, Christopher Cox. Okay? And they were based on secret data these people had seen, and they had leaked to the New York Times, and they were used to write these lurid stories about how this mysterious Chinese scientist, who by the way was from Taiwan, and he didn't even like the mainland. When he had a holiday, he went to Europe because he preferred classical opera to Chinese opera. It was his excuse. He was not political. I mean, the whole thing was outrageous. It was all based on documents of far higher secrecy than anything Snowden has seen that we know of. Okay, far higher. I'll give you one final example of the double standard. Okay, you had the Pentagon Papers. That's the most famous case before the current thing. And you had Daniel Ellsberg, right? And Daniel Ellsberg and Tony Russo wrote up here at the Rand Corporation. You had a study that was stamped secret. Why was it stamped secret, the Pentagon Papers? It was all stuff, as it turned out, when the Washington Post went to court and others, that you could have gotten in the public domain. It was stamped secret because it was a study of history that McNamara had commissioned that turned out to be incredibly embarrassing to the government, both whether it's Republican or Democratic government. It contained the tissue of lies justifying our going to Vietnam. And it went through everything, everything. It wasn't that the enemy would learn something they didn't know. It wasn't about troop movements. No, it was about information that was embarrassing. Embarrassing, okay? And Daniel Ellsberg, who had been pro-war, had been over in Vietnam, had been gung-ho, was involved with this study, as with Tony Russo, and he read this material, and they said, this is information the American public has a right to have. That's the principle now that's involved with Manning, there's Julian Assange, and Snowden. And you look at any of that information as information we need in order to make decisions about how our money is spent and our role in the world, okay? And unfortunately, the Ellsberg Pentagon case was thrown out not on a matter of principle of that we had the right, but rather because it turned out the judge had been offered a job by Richard Nixon as head of the FBI and the whole procedure. So we never even got clarity on that. But the basic principle here goes back to what George Washington talked about. If you want to be a republic of free people, you can't have your basic decision-making about war and peace decided on the basis of a classification system that one side of the debate has control over. That's what's going to happen as you happen with Iraq. You're going to be lied to. I'll give you one final example on this court. Because sometimes it's said, well, you can't really have these big secrets, and I've been that way going back to my grandpa's days. I've always been beating conspiracy people over the head, you know, and you couldn't really understand. I'll give you one final example. I was at the LA Times one day, and I had done a lot of freedom of information stuff and everything. I found out the Gulf of Tonkin, you know, the Gulf of Tonkin. I finally got these documents that were being released, and I got them fast, that showed the Gulf of Tonkin, which was the excuse for our going into war, right? The second attack had never happened. And that our government knew in real time, before Johnson went on television, that it had not happened, or that there was certainly no evidence that it had happened, okay? And in fact, one of the Admiral Stockton who ran with Ross Perot, he was a pilot. He flew above it that night. He went to bed. They woke him up. They said, we're attacking North Vietnam. He said, well, what for? And they said, because of the attack last night. I said, there was no attack. I was in my, that's in his book. Okay, but he was shot down. We never got that information. For 20 years, people kept that information from us. Hundreds knew that it never happened, okay? These documents came out, and I remember, I went downstairs and I talked to our publisher, Tom Johnson, who had been in the Johnson White House, and I said, we got these documents, and it looks like you guys all knew this was a lie. And he said, well, I didn't, but I said, I suspected it. He looked, I said, we have to publish it, to his credit. But here, he didn't even know, and he was right at Johnson's side. Again, justification for a war that could not be justified. So I want to conclude by saying, don't be fooled by the argument that national security requires the destruction of civility and freedom, okay? The opposite is true. The founders put the protection of freedom in our Constitution because they thought it would make us stronger, not because they thought it was an indulgence when you have no problems. You have to understand that. We would be stronger had we not wasted all the resources and lives and killed 3.5 million people in Indochina. We would be stronger had we not gone to war in Iraq on a false basis, okay? We'd be stronger if we knew more about what we're going to do with all these weapons when we're producing, you know, spending more than the rest of the world combined, et cetera, et cetera. So the main argument to be made when you go out there and talk to other Democrats is to say, don't tell me we need to do this to be stronger. Lies make us weaker. Truth makes us stronger.